Well, everybody, good afternoon. I want to welcome everybody to our first in-person O'Donnell public meeting. My name is Perry Turner. I am the Deputy County Administrator for Justice and Safety here in Harris County. There's a lot of misinformation that attempts to equate bail reform with an increase in violent crime and an attempt to associate bail reform with undermining law enforcement. That misinformation confuses the public. Misdemeanor bail reform in Harris County began under the O'Donnell case and was necessary because individuals charged with low-level misdemeanor offenses were sitting in jail longer than what is permitted by the U.S. Constitution, not because they posed a threat to public safety, but simply because they could not afford to pay cash bail. The cash bail system remains unchanged for felony cases. For those of you that are new here, the O'Donnell consent decree was created following a class action lawsuit against Harris County from plaintiff Miranda O'Donnell, claiming that the bail system was unconstitutional. Specifically, Ms. O'Donnell reported that after being arrested for driving with an invalid license, she was detained in the Harris County Jail because she could not afford to pay her $2,500 bail. The parties involved in this lawsuit subsequently reached a settlement agreement known as the O'Donnell consent decree. All parties recognize that input and involvement of Harris County residents will be essential to meaningful and lasting reform and effective for ongoing monitoring and evaluation of the criminal justice system. As a result of this consent decree, public meetings occur every 6 months. Today, Independent Court Monitor Professor Brandon Garrett, Deputy Monitor Professor Sandra Guerra-Thompson, and representatives of Harris County Attorney's Office, Sheriff's Office, and presiding judge of the Criminal Courts of Law will discuss the 5th Monitor's report, including consent decree implementation, updates, and completed milestones. After these presentations, we will allow public comments and questions. But before we commence with our program, I would like to recognize Breon Cummings, our program manager, for her hard work and dedication. So thank you, Breon. We really appreciate your efforts. And also, as I mentioned, our monitor team will make a presentation, followed by the County Attorney's Office, followed by the Sheriff's Office, followed by the Criminal Courts of Law, and then there will be a Q&A period. So once again, thank you for your partnership and support in addressing this process. Thank you. I'll turn it over to the monitors.
Great. Well, thank you. It's a real treat to be here with you all in person. Sandy and I and Dottie Carmichael, who's sitting here, and the others on our team who couldn't be here in person today. We've been doing this work for 2.5 years now. We've never been able to have a public meeting in person. This is a lot better than the squares on the WebEx or whatever platform they were using. It's great to be here with Major Doherty and Rachel Frazier. And some of you in the audience we've collaborated with. We're looking forward to meeting those of you who we haven't met before. Thank you for coming. We think misdemeanor bail reform in Harris County is incredibly exciting and important, something for everyone in the county to be proud of, but it's not everyone's favorite topic. There are aspects of it which are kind of nerdy. As some of you know, the O'Donnell consent decree, it was litigated for many years before we were involved. We are law professors and lawyers, but we were not the lawyers who brought this case. We were not involved in any way in the litigation. It was after the case had already settled between the parties that the consent decree asked that someone from the outside volunteer to come in and serve in this role to be an independent monitor to assess what was happening and to report to the federal judge on the progress of this consent decree for 7 years, and we're 2.5 years in. And Sandy and I had known each other for a long time and trusted each other that working on a 7-year project together would be worthwhile and important because of the importance of this consent decree, both in Harris County, and it's a model nationwide. As you know, this consent decree has permitted tens of thousands of people who are arrested for low-level, largely nonviolent offenses, but not all nonviolent, to be released without the need to pay money to secure their liberty. We believe that this framework is both important for accomplishing public safety and fairness goals. This was a constitutional case. It was designed to, the remedies were designed to protect the constitutional rights of arrestees, but public safety is an important public value. And I think one theme in our findings since the very beginning has been something that is sometimes surprising to people, that you can both protect your people's rights and accomplish public safety at the same time. It's not a trade-off. You don't have to strip people of their rights to feel safe in your community. Providing actually better process and more fairness can actually enhance public safety. That is, in general, what we have seen. We have very detailed findings in our reports. This fifth report, I feel like these reports do keep growing in terms of tables and figures, and part of that is because of the incredible collaboration we've had with the parties that have supplied more sophisticated data with us over time. But overall, what we show is that as these tens of thousands of people now have a right to release, they have a right not to be held based on unaffordable bond unless there's a strong public safety risk. These decisions are being made more closely keyed to public safety. And maybe no surprise then that you have tens of thousands of people who earn their liberty readily, and more people who are freed in misdemeanor cases in the community. And that said, what we see is misdemeanor arrests declining over time, and we see rearrests stable in terms of rates, declining in terms of numbers. And so, we see just a smaller misdemeanor docket in Harris County. And this is very much like a different world from what you may be hearing in the news about crime in Harris County, including because the felony space is different. I live in North Carolina. I'm not from North Carolina, but I live in Durham, North Carolina, where I teach at Duke. Durham is a small town, but compared to Houston, we've had shootings up in, there like we've seen all around the country. But in the misdemeanor space, the results of this bail reform have been incredibly positive. There's some more detailed findings that I wanted to briefly mention. I also wanted to highlight that OJS, the county has made available a public dashboard where you don't have to wait for our 6-month report. It doesn't have all of the data that we are reporting on, but it has a lot of really important elements where you can see trends in the misdemeanor bail space in Harris County, and you can check the website every day. It's updated. So that dashboard is a really wonderful feature that it was part of the consent decree that these data should just be accessible. People should be able to see what's happening in the misdemeanor system on their own without waiting for our filings with the federal judge every 6 months. A few other things I just wanted to highlight from our lengthy report, and then I want to turn things over to Sandy. Some of the trends that we're seeing in the misdemeanor space can be tied to these reforms, and we can say some things about the impact of these reforms. An outside group, the Quattrone Center at the University of Pennsylvania, independently did, we're independent too, but they're independent of the Independent Monitor. These other academics looked at doing regressions to look at the causal impact of the preliminary injunction that was entered as the O'Donnell litigation was moving towards settlement. And they found, consistent with our findings, that there was much less reliance on jail time, many fewer jailed misdemeanor arrestees, but also positive impacts on public safety, where arrestees following the change had reduced repeat contacts with the criminal system, which is what we want, right? We want, if someone is arrested, we don't want them arrested again. We want that to be the end of their interaction with the criminal system. We are also doing our own causal analysis of that type, and have been finding same results, that there have been these positive impacts of public safety. We are also looking more carefully at the costs and cost savings involved in the system, and also who are the people coming into the misdemeanor system and coming back into the misdemeanor system. We have some information in this report about people who are flagged as homeless, unhoused. We've been able to work with better information on that over time, especially thanks to the county and the hard work of the data team in OJS. It does look like one part of the story in terms of the decline in misdemeanor arrests over the last 5-6 years has been the decline in misdemeanor arrests of people who are homeless. We are also continuing to try to explore whether we can do more to understand data concerning people with mental health needs. We have, I think some of you may know, there were real marked racial disparities in who could afford a cash bond and who couldn't under the old cash bail system in place before O'Donnell. Early on in our reporting, we saw that those racial disparities in who bonded out and who didn't just disappeared when these reforms took effect. And we've seen that over the last 6 months, same thing. We've seen this sort of steady state where those racial disparities vanished and have. Now, that said, we do see differences in terms of the racial makeup of who gets arrested for misdemeanors in the first place. And we have some more geographic data and show that it's sort of a complicated story, that some of the biggest declines in misdemeanor arrests have been in largely black and poorer neighborhoods, which is positive, but that given how misdemeanor arrests were concentrated in those neighborhoods beforehand, although there have been improvements, you still see that much more than representation in the population, more black and also more poor people are arrested for misdemeanors. A few other things I just wanted to mention. We have described what happens at the bail hearings. There are now public defenders at those hearings, which there wasn't even representation before this consent decree. The hearings are longer. The findings need to be more detailed if there is going to be someone held on a secured bond in a misdemeanor case. There has been work focused on providing supports for a court appearance after the bail hearing when someone's case is proceeding to trial. You may have seen some news coverage of a non-academic report claiming that like in 80% of cases or something like that, people do not show up for court. That headline may have been sensational and eye-catching. It was false. And we think it's important to correct the record on that because it would be a public safety damaging impression for people to have that, oh, you don't have to show up for court in misdemeanor cases, no problem. That is far from the case. And when you actually look at the data that is present on court appearance, it's actually quite the reverse. It sounds like they're including lots of cases in which people were not supposed to be in court. They were not required to be in court. Many misdemeanor settings are ones where the lawyers are talking about, did we get the body cam video? How long is it going to take for the lab to run the tests? And judges don't require that the person be there, which is sensible that the person didn't appear if the judge didn't want them to be there. There were actually several thousand cases where people showed up for misdemeanor court when they were not required to, which was, I guess, nice of them to do, but probably not necessary. But again, cases go forward, often handled by the lawyers for more routine appearances, which is why appearance is not normally required. There are appearances where appearance is required, and the county has committed to hard work to try to improve appearance where it is important for cases to move forward. And this consent decree allocates funding towards that goal, and work is being done to think about the best uses of that funding. There's been hard work on that topic done already. There's an electronic court appearance system translated to multiple languages so that people have convenient ways to get notified, just like you do if you have a prescription ready at the pharmacy. And so there was a lot of work done to implement that system, which came online more than a year ago. There are also clear and more consistent court appearance policies under this consent decree. Whereas in the past, there was a lot of individual discretion as to what counts as a non-appearance. The definitions are uniform. That's not to say that there isn't discretion in terms of what judges prefer for certain types of appearances, but it was a real change under this consent decree in terms of when appearance needs to be required and what the consequences are for failing to appear. And there are consequences. There are some cases where someone suffers severe consequences for not appearing when it's required. And this year so far, it's been, I think, 700-something cases where there was bond forfeiture due to willful noncompliance. It is something that happens. People in misdemeanor cases need to know, and I'm sure their lawyers tell them that there are real consequences for willful non-appearance. But 700-something cases is not 80% of misdemeanor cases. There are tens of thousands of misdemeanor cases in Harris County. So we just wanted to note that that particular coverage gives a very misleading impression of the hard work that is going on in the courts and what these dockets actually look like. There is other hard work being done in response to recommendations surrounding improvement of indigent defense in misdemeanor cases, including after the bail hearings. There is also hard work to be done, and there's a new vendor that's providing trainings because although it's been 2.5 years, this entire approach towards misdemeanor work is different than what was done in the past, and we continue to have, we have the recent hires of new hearing officers, new lawyers. Sandy and I teach at law schools. We're graduating, bright young lawyers every year, and we met some both new assistant district attorneys and new public defenders this morning in the misdemeanor courts, and so new lawyers need to be introduced to how the misdemeanor bail system works, and that training is a really crucial part of this work as well. So that's I guess just a brief overview of some of our findings and some of the hard work that's still being done to implement this consent decree. Maybe I could turn things over to you, Sandy,
Sure.
and then to Rachel Major-Dougherty.
So, good afternoon, everybody. As Brandon said, my name is Sandra Guerra Thompson. I'm a professor at the University of Houston Law Center. And before O'Donnell was, finalized, I had spent many years talking to people throughout Houston and Harris County about the bail system and, urging community leaders to try to implement some improvement, because what we did see were so many poor people who really had no good reason to be in jail, but who were unable to gain their release because they couldn't afford the bail. And we saw the devastating effects of that and the racial disparities that was caused by a system that essentially required people to pay for them to get out of jail. So one of my jobs, my main role on the monitor team is to continue to connect with the community. So we have quarterly meetings with a community group, and this group represents law enforcement. We have 2 retired members of HPD, high-ranking officials. We have civil rights advocates, people who represent immigrants, survivors of domestic violence, women who have gone through the jail system, the homeless, and others who provide health care for the homeless and people with mental illness, as well as the downtown business community. And with this group, we have presentations and we learn a lot about how the system in Harris County is working. We talk directly with service providers for the homeless and people with mental illness, juveniles. We talk to advocates who are, looking for reform measures to better protect immigrants going through the system, to protect the survivors of domestic violence. We hear from law enforcement. In fact, we've been working very closely, obviously, with the Sheriff's Department because they're one of the parties in the litigation, but also with Chief Finner at HPD, who has been very helpful to us in providing police data and in talking to us, and so we're very grateful for that. We've also met with the head of the Houston Sobriety Center, the leadership team at Harris Health, members of Commissioner's Court staff, and many other departments across Harris County. We're extremely grateful for the cooperation with Harris County Pretrial Services, for example, which is a key component of the proper implementation of any bail reform. So through all of that, as Brandon has said, there have been a number of improvements to the system, and a large part of this really focuses on trying to get people who are arrested some of the attention they need. They come into the system usually because they're in some kind of crisis, they're having some problem that ultimately results in their getting arrested. And so some of the improvements that we've seen, as Brandon said, there's better court notification system in place. There's also new court forms that were translated into several languages. So if someone has a bond and they're getting out of jail, they need to know what the terms of that bond are. But if they don't understand the language, it's not accessible. So those forms have now been translated. As he said, we have better hearings for them. So they no longer go through the original bail hearing in front of a magistrate without a lawyer. That's how it used to be before O'Donnell. People didn't have a lawyer at those hearings to defend them, and now they do. And the magistrates are better trained now, so they're able to help people understand what's required of them and explain to them their rights before they leave the jail, as well as when they return to court for their first appearance and appear before an elected judge. We also have just better defense. So those lawyers who are there are represented at the initial hearing are representatives of the Harris County Public Defender's Office, and they're specially trained to do the kind of work that they're doing. Many of the lawyers who will later be appointed are private attorneys, but they're now managed by the Office of Managed Assigned Counsel. So this is another innovation that Harris County has implemented in order to better supervise those appointed lawyers, because we heard for years and years about appointed lawyers, taking county money to handle cases, but then not doing a very good job. Well, now you have this new office, this county office of Managed Assigned Counsel, that is providing this kind of oversight and accountability. So that's another huge improvement that is just getting off the ground still, but we should expect to see much improvement in the future. And both of these offices are really moving in the direction of another new type of system, which is called holistic defense. And the idea there is to better engage clients, not only with their lawyer and their legal rights, but also with the community service providers who are out there who can help them, so that they not only have a good lawyer standing next to them in court, but they also have people in the community who can help them to get their lives back in order. So, the other thing I will say is that at the misdemeanor level in particular, there are also a lot of programs that are operated through the district attorney's office in cooperation with other county agencies, so that instead of prosecuting people, they go through various programs to try to help them. And if they complete those programs, then their charges are dismissed. So we see a very high rate of dismissal in Harris County of low-level cases, of these misdemeanor cases. But it's not that the cases are just going away and nothing happened, right? So people are completing these programs at a very high rate and having the kind of intervention that will enable them not to get rearrested and to go on and live more productive, law-abiding lives. So it's really an effort of the community and a lot of the private community service providers cooperating with county officials at all levels of Harris County government to connect with them and to help them in their lives. And I do want to underscore as well the real importance of the Office of Justice and Safety in gathering the data and having that data in one place where we can look at it on this dashboard. Making that information public is super helpful, not only for county people who want to see what's happening in the county. They can keep that internal and they can do that on their own. But by making it public, it makes it accessible to academics, right, to service providers who are studying it and trying to figure out what are the best practices and what are we seeing happening, what are the trends, what works, what doesn't work. So I think the overall picture is one of a project that is only 2 years into a 7-year project. So it's, it's often talked about how Harris County is so big and the system is so big. And of course, we're just coming out of COVID, right, which followed right on the heels of Hurricane Harvey. So the system had a lot of catching up to do. And it's a lot of change that has come about because of O'Donnell as well. But overall, we're really starting to see things turning in the right direction. As Brandon said, those disparities, racial and ethnic disparities of who got out of jail without having to pay, or who got out of jail at all, have really largely gone away. And what that represents are lives of thousands and thousands of people who didn't sit in jail for 3 days, for 5 days, who didn't lose their jobs, who didn't lose their apartments, who didn't lose custody of their children, and who were able to go on and continue in their lives, and then connecting again with those community service providers who could help them through the process to try to prevent them from ever getting arrested again. So we really are seeing a lot of progress. It's still a long way before we're done, but we're just, happy to be here and hope to answer any questions that you all may have. Thank you.
Okay, we'll turn it over to our county attorney, Rachel Frazier.
Good afternoon. My name is Rachel Frazier. I'm an assistant county attorney, and thank you, Brandon and Sandy. That was fantastic. At the county attorney's office, we are here to provide legal support, and we're working with the stakeholders to try to ensure a constitutional and transparent system while at the same time maintaining public safety. We are continuing to provide legal advice, consultation, contract management, and assistance in ongoing decree obligations, including improving court appearances, and we're working to implement recommendations from the non-appearance study. We're continuing to provide legal support relating to the data portal. I know Sandy mentioned the transparency and the public data. We are providing legal support in procuring vendors, or did provide it, in procuring vendors for training opportunities, providing legal assistance in implementing the Indigent Defense Plan, which is from recommendations from the NAPD, National Association for Public Defense, and we're continuing to meet with the parties and the stakeholders and continuing to assist and provide feedback. We will continue to assist the county in implementing improvements to the pretrial misdemeanor system and to facilitate compliance with the consent decree in the future.
Okay, Major Doherty, Harris County Sheriff's Office.
Good morning. On behalf of Sheriff Ed Gonzalez and the Harris County Sheriff's Office, my name is Major Doherty. I'm the Bureau Commander over the Joint Processing Center. The Joint Processing Center is the place where all persons who are arrested and all persons who are released from the Harris County Jail will come. Our role in this project is that we are the action item. We process the person through the system. We act upon what the consent decree requires. We act upon what judges and the court system requires us to do. While they're in our custody, the person will be charged. The person will see the pretrial services. The person's cases will be reviewed by the magistrates. They will receive bonds, and we will process those people through the system. Whether it's a pretrial services bond, whether it's a cash bond, surety bond, those people will be released or by order of the court or no PC. All those things happen inside our building. We work very closely with the bond monitors to provide them with the necessary information they need to instruct us on making sure that we are following the edicts of the consent decree. If there's any questions I can answer, please feel free.
Okay, last but not least, the County Criminal Courts at Law, Presiding Judge, Genesis Draper.
Good afternoon. My name is Genesis Draper. I'm the presiding judge of Harris County Criminal Court at Law number 12. I am also the presiding judge for all 16 misdemeanor courts. Pardon my tardiness. I also have a full docket, including on Fridays, and so I came over as soon as I could, but did have a chance to hear some of the highlights of some of the presenters before, so I won't belabor the point and go back over all of those things. Some of the things that have occurred in misdemeanor court, so obviously when we entered into the consent decree, that adjustment brought about some growing pains, and so we've been adjusting as those arise. And some of the changes that have been made included adding pretrial services officers in individual courtrooms. That has been a real difference maker for us to be able to be notified of any issues with pretrial release as they're happening. We're not up to real time yet, but a lot swifter than we were when we first entered into this agreement. Because of course, if you are releasing people at the rate at which we are in misdemeanor court, you do need to be able to also appropriately supervise those who need to be supervised. And so that has been a great addition to many of our courts. We are still not fully staffed in the pretrial services department, so there is not one in every court, and there are still courtrooms sharing pretrial services officers, but we are hoping to solve that in the near future. Additionally, one of the other things that has flowed from bail reform is delay in cases, right? I think we talk about those two things separately, bail reform and then, the backlog. Well, one thing that I think not everybody realizes that when you start releasing people who are accused of crimes, then those people get to adequately fight their case, right? And so instead of pleading guilty to get out of jail to things they may or may not have done, now you have people out on bond who actually want to see the evidence that they're entitled to see in their case. And that has really upset our system, right? Law enforcement agencies, other investigative agencies, were not having to provide the volume of discovery that they are having to provide at this point. And so our agencies are having to adjust, and to their credit, they're doing that, right? It used to be quite a long delay to get a body camera, but the sheriff's office has made some adjustments in their system, and so I think here in the very near future, their cases will turn, their videos will turn around much quickly. HPD made some changes, and so we're having to adjust and provide people the discovery, the evidence that they are entitled to when they are accused. But we are making those necessary adjustments, and some of the courts have implemented scheduling orders, so to give the parties expectations of when discovery should be due, and having that trickle down to these agencies to let them know we're not going to be able to accept 450 days as an appropriate length of time to resolve a misdemeanor. And so that's a slower process, but we are certainly monitoring that and making sure that we work efficiently to improve that. Some other things that have been mentioned is our ability to communicate with people regarding when their court dates are. We've also made the courts more available. You can call just about any court right in the middle of the day, right in the middle of our docket, and somebody will answer. And there will be someone there for you to say, hey, I missed, hey, I'm sick, hey, I'm in the hospital, so that we can kind of keep better track of people that do not appear in court, so that we have an idea of what might be going on. Additionally, fewer people fall through the cracks. By way of an example, one of the things that delayed me today is that there was an individual on my docket that I could not figure out why they had not been brought to court for their bail hearing, since several days had delayed since they had initially appeared at the JPC. And so before, things are moving so quickly, nobody looks at that. And so I can say, hey, I have this one person here, it appears they were arrested a few days ago. They haven't been brought to court. Let's find out why that is the case. And so this structure and this reform has made it a lot easier to identify those holes in the cracks so that we can make sure that people don't slip through them. So the short version is the state of the union is good, but there is still a lot of work to be done, and we welcome the opportunity to work with our justice partners in making sure that bail reform continues to improve the way in which our system provides fairness and justness, but also public safety. And so I welcome any questions that people might have. One other thing, I should also say it was referenced, but the Office of Managed Assigned Counsel, that has been an addition. I noticed that the director is here at the back of the room, and I recently received a report from him, and that's another way that we try and keep up with individuals. We don't have everybody's phone number that gets accused, and so now they are linked up with lawyers, but a lot of those lawyers are solo practitioners, and so now there's an agency that is able to provide them support, able to provide them. When I worked at the Public Defender's Office, there was a standard form that was given to me, so I knew how to get information from a person, to keep up with them, to make sure that I had backup numbers. A solo practitioner might not necessarily know to have that, might not necessarily be able to provide that now is available at the Office of Managed Assigned Counsel. Those are ways in which, one, it supports bail reform, but also it supports indigent defense as a whole, which makes our system better. And so I did want to shout that out because we've seen significant improvements in our indigent defense system and the support that our lawyers receive, an increase in investigative hours, an increase in the diversity of the lawyers who take appointments. And so I didn't want to miss the opportunity to shout out that improvement and the way in which it's connected to bail reform.
Okay, now it's time for our Q&A session. I'll turn it over to Ms. Cummings.
Yes, if you have a question, you can come to the podium, state your name and your affiliation, and we'll do our best to answer.
Any questions? Don't be shy.
All right, well, if there are no questions, if there are any final remarks or anything that you would like to leave us with, you all can go ahead.
Just trying to decide whether there are other topics we could talk about. I guess one just quick thing to say is that one type of case that we talk about in our report, which I don't think Sandy wrote a note and said, we haven't talked about the carve-outs versus the non-carve-outs, but that for folks that aren't familiar with the way that the consent decree is structured, there are some cases where the default is if you get arrested on a misdemeanor, you get released after booking. The cases that are carve-outs are the ones where there's a greater public safety concern and you are absolutely not entitled to an automatic release. You have a hearing in front of a magistrate and there's an inquiry, and there's more time to have that inquiry because it's not every case. Before this consent decree, every misdemeanor would go to a bail hearing, and the bail hearings were like 30 seconds long. There wasn't really time to really look into public safety. There was a bail schedule. You just ask what the person was arrested for and say, oh, that's a $2,000 case, that's a $3,000 case. Now there's a public safety focused inquiry. The carve-out offenses include things like a domestic violence arrest, a violent misdemeanor, also violations of bond or parole or supervision. In general, in tracking what happens in those cases, the biggest change in terms of these carve-out cases is that there are more people out on bond, so more of those cases involve bond failures. In general, the other categories of carve-outs, there was an increase in DUIs and repeat DUIs from 8 to 10% of these cases, which actually was before the pandemic. We all heard about and probably saw some of the terrible driving in our communities during the pandemic. But that was actually a trend, pre-pandemic trend, that we saw a modest but steady increase in DUIs. We haven't seen that more recently. Similarly, there was a pre-existing, actually not just a pandemic thing, but there was a modestly growing share of domestic violence misdemeanor arrests. In general, what we've seen, though, is not that those more serious misdemeanors are increasing, but that the number of misdemeanors is decreasing and those are remaining the same, which means that more of the misdemeanor cases that our courts are hearing are more serious and important ones. But that's because, I mentioned that we are seeing many fewer arrests of homeless people. Like the minor cases of the homeless person stealing a toothbrush at Walgreens and the like, the cases that looked like sort of a citation for being out of place, behaving rudely, minor theft, shoplifting. There are many thousands fewer of those cases every year. There are also, many thousands fewer marijuana cases every year because of the district attorney's diversion program. So we have, maybe 10,000 less misdemeanor cases a year, which is a lot of cases and a lot of people. But what that means is that the cases that are left are, on average, somewhat more of the serious ones. And those cases absolutely go to a bail hearing, a much more robust one than before. You have a public defender. You also have the prosecutor able to make more of a case for why the person raises a public safety risk. There's just much more of a discussion of what the options are. The one last point I wanted to make is that sometimes you hear, and especially people who, don't spend lots of time watching bail hearings, which is, good. But some of us would rather watch Netflix than watch bail hearings, but I watch a lot of bail hearings. These aren't just in-out, thumbs up, thumbs down choices. It's incredibly important that the right conditions be imposed if someone is released in the community, and if a secured bond is set, that the right conditions be imposed, because neither the hearing officer or the judge may firmly know whether someone can make a secured bond or not. And so they may think that this person is a public safety risk, a $10,000 bond is appropriate. Someone may not have an interest in telling them that they can easily get that money from their cousin. And so it's very important that the protective order, whatever the safety measures that are needed, are associated with that bond. And there are also important questions, and pretrial services has been doing a lot of work to think through this better. If someone is going to be released into the community, what are the conditions that'll set that person up for success and assure public safety? Because just flat out release may not be appropriate, and there can be some conditions that can be counterproductive. And if you have the person having to report every week and they lose their job because they can't make the hours at the workplace, then you may not be doing good things for public safety by setting that person up for failure. And so there's a lot of careful thought that goes into what are the right conditions to assure safety and appropriately supervise someone. The choice is not just set the person free and put them in jail. And that said, like those are not easy choices, and they can be adapted over time. Obviously, if the conditions aren't working, they can be changed over the months that a case goes forward, and we see that quite a bit. Obviously, you get new information, like Judge Draper was saying. Pretrial services, ideally, is in the courtroom. It can say, like, we need to make a modification here. This isn't working, or this isn't necessary anymore.
Yeah, and I would just add too that one thing we haven't really mentioned, Brandon referred to fewer arrests of homeless people, and from where we sit, from what we can tell, a lot of that is the credit again of Harris County and City of Houston and the service providers that help homelessness in the city, who have poured millions, tens of millions of dollars into addressing the problem, and have been quite successful from what we can see, and in fact have gotten national coverage for the programs that they've implemented, the facilities that have been made available to try to help people have a safe place to live and to avoid homelessness as well. And the result, we're not really addressing homelessness directly, but it's a big part. It was a very big part of the misdemeanor docket. Was police officers feeling like they had to arrest someone who was homeless, but who was acting in a way that created a problem for the community, or maybe a safety issue for the individual or the public. So. We've seen some real progress in that as well. But I just had to give a shout out to all the people in our city, in our county, who are trying to address this issue of homelessness, and have been really successful in doing it in an innovative way that is causing people from a lot of other major cities to want to study Houston.
That is correct. All right, well, thank you all for your time today. For all those that have watched on live stream, we will be doing this again next Thursday, October the 13th at 6 o'clock. You will have another opportunity to ask questions in that forum. So if you have questions or think of something later, please join us at this time. Additionally, as a consent decree requirement, we do this every 6 months. So this will come up again in about March or April of next year. And so we look forward to dialoguing with you all. Thank you so much for your time today, and thank all of our presenters.
Thank you.